Good morning, everybody. I'm Carolyn with Midwest Manufacturers Association, and I'm excited to have you joining us for our Workforce Development webinar series. And today we are going to be talking about Employment Law 101 for manufacturers with our special guest, Bethany Venegoni from Taft Law. And I'm going to turn it over to you, Bethany.
Thank you so much, and thank you for having me. Good morning, everyone. So as indicated by my slide here, we're going to be talking about employment law for manufacturing. So I am an employment attorney. I practice specifically in employment, but I also have a practice as it relates to benefits, compensation, basically anything and everything HR related. I spent around 7 years practicing as an HR professional before I switched careers, went to law school to pursue employment law. And actually, my final job in HR was with a manufacturer. So I have a lot of hands-on practical experience. So I represent a lot of manufacturers just because I have a better practical sense on how the law applies as well as where the pinch points are. So I'm super excited to talk to you guys today. And if at any point anyone has any questions, just feel free to unmute, interrupt, bring up your questions, and let's get them answered and talked through in real time, because I find with these presentations that always leads to a much more robust conversation and learnings for everyone. All right. Okay, so key discussion points today. We're going to be talking about different topics under the headers of hiring, performance management, termination, and almost everything in between. I'm always required to say this, and it's never come up before, but just so everyone knows, all the information I'm going to be providing today, it's not legal advice. Yes, I am an attorney, but there's no attorney-client privilege in these conversations. So just be mindful of that. You're certainly welcome to ask me specific questions in the form of a hypothetical, and I am happy to answer. Okay, so let's dig in. Hiring. First on my slide here, the state of residence matters. So I'm not sure if everyone in the group here, I know everyone has their cameras turned off. Usually I ask just by a show of hands, who in the room has employees in multiple states, but since cameras are off, I won't make you guys turn them on just to indicate whether or not you have out-of-state employees. But, when I'm advising, oh, great, I see a hand, wonderful. Okay, so this won't fall on deaf ears to absolutely everyone. I hope it's applicable to everyone, but the state of residence obviously matters in a big way. When you're in the hiring process, the first thing that I always advise is check the posting requirement before you get before you get the job advertisement up. Do you need to include compensation within the job posting? Do you need to include information on benefits? This stuff varies state by state. For example, Minnesota enacted the pay transparency law, which if you have 30 or more employees in the state of Minnesota, you are required to include a host of different areas of information within a job advertisement, which does include compensation and benefits. Check the state's website on hiring requirements as it relates to notices, sick time, posters, policy requirements. Really get your bearings on understanding what is needed in the particular state before you start making hiring or interview selections. The worst thing not the worst thing, but one thing you typically want to avoid is allowing a manager or supervisor to interview an absolute rock star and just to find out, oh, actually, we don't want to deal with all the laws of that state. So you cannot pick that individual. You have to pick someone else. Really getting your bearings on what those requirements are before you make selections for interviews is really helpful. And then are your agreements compliant in the state where you're looking at? So agreements going beyond signed job offers or employment agreements, agreements as they relate to confidentiality, non-solicitation, non-compete, and assignment of invention. All of those, what we refer to as restrictive covenants, those are all going to vary state by state. And some states don't really have a ton of case law or any statutes governing them or controlling them, but a lot of states do. And you really want to be mindful that your agreements are going to be enforceable in the states where you are hiring. As how long have non-competes been banned in Minnesota? Great question. July of 2024. The law was not retroactive though. So for your folks who signed non-competes prior to July of 2024, those are still enforcement so long as they are reasonable in scope. So for the duration and the geographic limitations, those are still going to be enforceable. But as of July 2024 and moving forward, they're not enforceable. Great question. Any questions anyone has about restrictive covenants or the ban on non-competes? Go ahead to unmute and ask questions now if you'd like. No? Okay. Okay, ensure your job description is up to date. Example, do you frequently terminate for poor attendance? Is reliable attendance listed as an essential function of the job in your job description? Now, this is not to say that we should go into every single job description that you have and add reliable attendance within the essential functions of every single job that you have. But in a manufacturing environment, chances are that your plant employees, so those employees who are on a tight production schedule and on the line every day, reliable attendance is going to be an essential function. And if your job description doesn't include reliable attendance as an essential function, it should really be added. Ensure your policies are up to date. So the example I have here, has your break policy been updated since Minnesota's law has changed? We'll get into more specifics about meal and rest breaks in a few slides here. So we'll hold on that, but you want to make sure all of your policies are up to date and compliant in the state that you're looking to hire. You know, and those meal and rest breaks, people don't really think are a huge deal, but getting hit with a wage theft or oh, Michelle H., good question. Copy of the presentation. Yes. After the presentation, I'm just going to go ahead and interrupt myself here. I will have my email listed and you can certainly reach out to me via email and I'll send you a copy. So you will want to make sure that your meal and rest break policies are compliant in the state that you're employing individuals as well. And again, these really do vary from state to state. Some states don't have any laws. And so it's just the federal law, the FLSA, that applies. That's not super detailed, or there aren't a ton of pinch points with the FLSA as it relates to rest breaks, but it's not something you want to mess around with, especially if you have an employee for years and years and years and they've never taken a break. Check for variances in drug testing laws. Yikes. These statutes are notoriously difficult to create policies that mesh with one another that can be compliant in every single state. It's virtually impossible. You really do have to have carve-outs for every single state because they're just so detailed and, you know, down to the timing of when you need to have them sign the consent forms for drug testing, the timing on when you need to send them the results, if you need to offer, you know, them the chance to attend like a chemical dependency or rehabilitational, a rehab place before you terminate. All of those rules vary greatly from state to state. So you really want to be mindful of those variances if you're going to be drug testing in multiple states. Onboarding. Once you make the determination to hire, ensure your agreements are signed on day one. There are a lot of states that require the restrictive covenants, so the non-solicitation and confidentiality agreements, that those be signed simultaneously with the employment agreement or on the first day of employment. Otherwise, they're not enforceable. Provide overview of handbook and other policies and obtain signatures on your acknowledgement page. If your handbook does not have an acknowledgement page, make sure you get that implemented ASAP because that is always a lovely exhibit one for employment attorneys. And I should have clarified, I'm an employment attorney for companies, not for individual plaintiffs. So that would be an exhibit I would like to include when defending an employer, is that the employee received copies of the policies, they received ample training on the policies, and even signed attesting to doing so. Ensure your drug testing consent forms are signed if you're drug testing on that first day. And then staying current, that's really challenging. Sign up for updates on state websites. For example, Minnesota has several different distribution lists. So whether you want to be signed up for updates as it relates to Minnesota paid leave, or whether it relates to cannabis laws, all of those different sections on Deed's website and Dolly's websites, they're all different distribution lists. So I recommend you peruse all the state's Department of Labor websites and get signed up for all of the alerts, just so you can be in the know when there are significant changes in the laws. Follow attorneys such as myself on LinkedIn, or you can also get signed up to be added to my distribution email list on all of the legal employment updates that I push out when changes are made or when there are significant holdings as it relates to employment law that employers should be aware of. And if you want to get on my email list, just shoot me an email after the presentation and I can add you. Ensure you're checking for notice, policy, and poster requirements at least annually in every state you have employees. Best practice is to check upon each new hire because those websites are continuously being revised and new notices being published that are required to be provided to employees. So just make sure you're keeping up to date on that. I would say pulling from the website for every new hire is best practice, because the last thing you want to do is just save all of the notices in an HR folder and just pump them out for every single hire and be sending outdated notices and forms, because then you're not really meeting the legal obligations to provide to your employees. Okay. Jumping into some of Minnesota's changes in, the last 4 or 5 years, it has been a whirlwind. Right now, it's not looking like we're going to get a ton of new legislation in on the employment side right now. I guess we still have until May 6th or 7th until session ends. That date might be wrong, but we're nearing the end of the session. And so far, there are some bills that have been introduced, but they're not gaining a ton of traction. So there were a lot of changes, though, in the last few years that a lot of employers just aren't aware of. So I'm going to be going through a host of different changes as it relates to Minnesota employees and as it specifically relates to pinch points that my clients in the manufacturing industry grapple with. Okay, so starting with the Minnesota pregnancy and parental leave law. So as you guys probably know, this is an unpaid leave for employees that bring new children into their families. So previously, there was a 10-year requirement for the employee to be with the organization for a certain amount of time prior to being afforded the benefits of this unpaid leave. But those 10-year requirements were removed in the law, I believe, in 2024. So you'll want to check your policies and make sure that that is up to date. Nursing mothers, lactating employees, and pregnancy accommodations law. This went through a ton of changes as well. So there's now a notice requirement, and you can pull the notice right off of the Minnesota DOLI's website. The notice needs to be provided to all new employees. When I'm working on handbooks for employers, I generally put a copy of that exact notice in the handbook, either in an addendum or within, the meat of the handbook, because there's also a handbook requirement too. And some employers try to draft their own notices that are compliant, but I just use the states because it's what they want to see anyways. So easy compliance box to check by just copy and pasting that right into your handbook. So along with those changes included compensable lactation breaks, as well as required accommodation for pregnant employees. School conference and activity leave. The tenure requirement for this law and this unpaid leave was also removed from the statute. So I still continuously see these policies in handbooks. Most employers don't even know they have them in their handbooks, let alone that the law changed. But just because employees don't frequently use it, so kind of falls by the wayside. But if you're making some changes or reviewing your handbook, good to take a look and make sure you don't have any type of tenure requirement in order for employees to access this unpaid benefit. Okay, cannabis drug testing, everyone's favorite topic. By a show of hands, I don't know if this will work for everyone or not, or if you know how to raise a little electronic hand, but does everyone here drug test employees? Or some of you, none of you? Okay. I will go through this briefly then, and if you have questions, feel free to unmute and throw out your questions, or you can drop them in the chat. And if I don't notice them, feel free to unmute yourself and just ask. But so cannabis was removed from the lawful drug testing list, but there are exceptions to that. So you can't test for cannabis unless one of those exceptions applies. Safety sensitive positions is by far the most common exception that employers are relying on, especially in manufacturing. So what constitutes a safety sensitive position is a super broad definition. So if someone could get hurt doing their job or hurt someone else, they're essentially going to, qualify as being in a safety sensitive position. Certainly if they're walking around a warehouse where there are forklifts, or if they're driving a forklift, or if they are, working on a printing machine like pad printing where there are a lot of pinch points, those are all safety sensitive because people could really get injured in those occupations. But it needs to be carved out in your policy if you're going to be testing for cannabis. So you want to make sure that your policies are up to date. I always define the roles that are subject to cannabis testing, just so there is no legal fight later down the line as to whether or not the employee was put on proper notice that they could be tested for cannabis and what those expectations and obligations look like. So definitely want to make sure to define that just to save yourself from a legal battle down the road. Excuse me. And train. You can have the best written, I'm going to say this a million times during this presentation, but you can have the best policies in the world that are written by the brightest and the best attorneys. And it doesn't mean anything if your supervisors are not aware of the legal obligations and what they're supposed to do under the policy. So I would say a million times over, drug testing is one of those topics you really want to make sure your supervisors have adequate training on so they understand the ins and outs. Obviously, if you have any DOT drivers, that drug testing policy is totally separate, needs to be completely separated from your regular drug testing policy. I mean, most of those are pretty large. Usually when I'm drafting a DOT drug testing policy, it's around 10 pages because there is so much content that federally under the regulations has to be included. So if you have DOT drivers and you don't have a separate policy, you should be having light bulbs going off right now to scribble that down to look into that. Okay, non-compete ban and shadow non-compete ban. So like I noted before, the non-compete law in Minnesota is not retroactive. Certain non-solicitation provisions will run afoul if they are too restrictive. So if an employee that has been terminated or resigned signed a non-solicitation on or after July 2024 when non-competes were banned, if those non-solicitation provisions have too far of a reach to the point where they are no longer able to work in their profession or trade, it's going to be viewed as a non-compete that is unenforceable under the law. So you really want to make sure that those non-solicitations are drafted very narrowly and very specific to your business, so that from the jump, when you're looking at the purpose, you can totally see the tie between what the business is trying to protect, which should be, obviously the goodwill and trade secrets and confidential information versus trying to strong arm employees into just staying at the business and never leaving. So in terms of shadow non-compete, so this really didn't get a lot of media attention when this passed. And most of the time when I'm reviewing and marking up vendor agreements or agreements with customers for companies, they're in total shock that they cannot have any anti-poaching provisions within their agreements with customers or vendors. An example that I like to give, because most people can identify with signing a contract with their daycare. I know this isn't applicable to manufacturing, but this is just always the example I give. So when you sign a contract with your daycare for them to provide services to your children, to care for them, usually somewhere in that agreement, there is some sort of provision snuck in there that prohibits you from hiring any of your staff to be nannies, because that is rampant in that business, and that is unlawful ever since the shadow non-compete was passed. So if you have vendor agreements or customer agreements or any type of contract that would limit a third party from hiring your employees, it's unenforceable in Minnesota. Any questions about that? Okay, breaks and rest periods. So the Minnesota law on breaks and rest periods changed effective January 1st of this year. So at least 15 minutes of paid rest time within 4 consecutive hours worked is now required, along with a 30-minute unpaid meal period when working 6 or more consecutive hours. This is a huge change. So previous to this change, it was that under Minnesota law, employees just needed adequate time to use the nearest restroom. And now we're moving to at least 15 minutes of paid rest time within each 4 consecutive hours. At least. So it can sometimes exceed 15 minutes under the law if the employee needs that time to use the restroom. The 30-minute unpaid meal period when working 6 or more consecutive hours, that's also a shift. While many employees, especially in manufacturing, were already being provided with 30 minutes of unpaid meal time, now it is a requirement, because previously it was just enough time to eat a meal. The remainder of bullets here is verbatim from what is currently on the Minnesota Department of Labor and Industries website in terms of employees waiving their breaks. So under Minnesota law, employers must allow their employees to take breaks and rest and meal breaks, sorry. An analysis of whether an employer allows their employee to take breaks is fact intensive and may include, but is not limited to, whether the employer has a breaks related policy. So key here, this is directly from Minnesota Department of Labor and Industry. Make sure you have a policy, step 1. The policies have been communicated to employees. So step 2, make sure it's in your handbook, make sure you get a signed acknowledgement. And work circumstances make it possible for employees to take breaks. So making sure that that time is carved out in the production schedule for them to take the breaks. If an employee voluntarily waives their breaks, it is best practice to confirm this in writing with the employee. That is always the route I have advised for employers, but seeing it right on the Minnesota Department of Labor and Industries website really makes it important, because these are key points that investigators are going to be looking at and determining whether or not employers are compliant under the law. And I saw a question here. Let me just see if I can get it pulled up, because it disappeared on me. Oops. Okay, how does the first bullet here apply to an employee working a 12-hour shift? Very good question. So if they're working a 12-hour shift, let's tackle the 30-minute unpaid meal period first, because, excuse me, under the law, as well as on the FAQ on the Minnesota Department of Labor and Industries website, they're real specific to this issue that employees are not required to have more than one meal period, and you can take the meal period out of the equation when calculating hours for purposes of breaks. So if you have someone working a 12-hour shift and they're going to be taking an unpaid 30-minute break, then technically you're looking at 11.5 hours that you need to figure out how many breaks. So 8, 9, 10. Yeah, so 2 breaks, right? Am I doing that math right? Because 3 would be 12 hours, but you subtract out that 30-minute. Yeah, that's correct. So 2 breaks in a meal period. Does that make sense, Amy? Okay, great, thank you. Okay, any other questions about meal breaks and rest periods? This is like such a tricky change to rearrange production schedules around this. So let me know if you have any questions. Okay, diving into earned sick and safe time changes. Let's see, can you have a blanket statement? This is from the chat. Can you have a blanket statement for when they don't take breaks? Minnesota Tool Group, I think this is in relation to having a blanket statement like in your handbook. Is that what you mean? So in the handbook, oh, to have employees sign. Yes, absolutely. You can totally create a form. That's a great practice to instate. So have a form out on the production floor for employees to be able to, or warehouse or office employees too, I guess, to have employees sign and attest that they are voluntarily waiving their meal period. Yes, that is a great practice. And then obviously slip it right into the file. Let's see. I also typically like to put in handbook policies, I like to put verbiage around an employee's obligation to report if their meal period is interrupted. Because if it's interrupted with work, it needs to be paid. So not only having that in the handbook, but also training employees on that obligation is important too. So, but what about if they change their mind and want a break one day? Oh, yes, yes, yes. So to be clear, the form should be completed for every single break that they skip. So if they skip that meal period on a Monday, a Tuesday, and a Wednesday, you should have form signed for all 3 days. And then the next they don't. Wouldn't it be easier? Yeah, you're going to want to have, you can't just do the blanket one form one time. Thank you for clarifying that, Kim Carlson. You have to, and yes, you can make them take the break for sure. Absolutely. That can also be a company policy. Great questions. Be good to move on to ESST. I know I'm like buzzing right through this. I just have so much content I want to get through, but we can certainly slow down and talk more about breaks too. Like the devil's kind of in the details with these policies. Okay. So earned sick and safe time changes. Gosh, I feel like this law is revised every 5 minutes. I know that's not the case, but that's kind of what it feels like. So the latest and greatest changes that became effective are that if an employer provides employees with paid time off or other paid leave that is more than the amount required under the ESST law. So to be clear, what we're talking about here is if you have, as an employer, a bucket or allotment of ESST, but then you also have a PTO bucket or a vacation bucket, you need to allow employees to take all of that time that has been earned for earned sick and safe time purposes and follow the laws of earned sick and safe time for those absences. So let's say you have an employee who has exhausted all of their earned sick and safe time, but they have a PTO bucket of 8 hours left. They call in sick and they elect to use that 8 hours of PTO. The documentation rules around not requiring a doctor's note, just upon one absence, that kicks in. not being able to count the absence against them in terms of a point system or progressive discipline policy or what have you, and not interfering with that time or making them find a replacement for that day. All of those laws apply to that time, even though it is technically not earned sick and safe time under your policies. Any questions about that change in the law? Okay. Oh boy, opposite of what your lawyers told us. They may not be aware of the change. So this is the Minnesota Department of Labor example. I checked the website this morning and I wasn't able to find this exact snapshot, but I have educated so many employers and done so many presentations to employers' supervisors to help them understand the law and the limitations that I still have this snippet from their website. So this is the example they had on their website when this change first was enacted. If an employee receives 50 hours of PTO in addition to the minimum requirement of 48 hours of ESST hours per year, the employer must follow the ESST requirements about notice, documentation, anti-retaliation, replacement workers, and more for the PTO hours in addition to the ESST hours. Importantly, these protections, okay, the importantly part, I'm going to be real with you. That's my text. That's not what was on the website. So now this is me speaking here. But the protections only apply when the time is used for a sick and safe purpose. So if they just don't show up on a Friday, and they don't claim any ESST purpose, like I have a migraine or I have a stomach ache or whatever, my kid's sick, if they just don't show up and they have no excuse, like, and they say, sorry, I stayed up too late playing games and I overslept, that's not protected. That can obviously, you can discipline them for that. Okay, what if you have one bucket for ESST and one bucket for PTO? Yeah, that's the exact example I'm given here. So that PTO is also protected if they use it for an ESST purpose. So when the ESST law was first enacted, they didn't have this rule in place. And so a lot of employers had policies where they differentiated between ESST and PTO so that they could discipline once the ESST was exhausted. But so this would be unlimited sick excuse time. Yeah, essentially, but it only applies to the time that's earned. So once all the earned time is gone, nothing's protected, right? So once those balances are exhausted, Kim, that's when you can start disciplining. I think I interrupted myself, but was that clear? If you have an unlimited PTO policy, that's really difficult to work around with these rules because an employee can potentially bring a retaliation suit at any point if they're disciplined for calling in sick because your policies don't have parameters around use. Let me know if you have any questions about actual unlimited policies. Those are kind of a nightmare coming from someone who has unlimited PTO. Okay, are we good to move on to some Minnesota paid leave pinch points? Yes, okay, awesome, thanks, Amy. Okay, so Minnesota paid leave, I have been living and breathing for years, literally. So I am the go-to expert in our Minneapolis office for all leave policies, obviously with my HR background and benefits law experience as well as employment law experience. And it has been an absolute minefield. The primary, I know everyone's probably super exhausted of even talking about this topic, but the major pinch points that a lot of employers are experiencing right now. How do we modify our paid leave policies? How do we incorporate Minnesota paid leave when taking into consideration FMLA, Minnesota parental leave law, ESST, just everything? Or if you also have a company paid leave for parental leave, kind of how do you meld those all together? So if you haven't done anything with your policies, the major takeaway here is it deserves attention. especially if you do not have a policy that expressly states whether or not employees can take their PTO while they're using Minnesota paid leave. If you don't have a policy supplementing, it's going to be pretty darn hard to prohibit an employee from supplementing that time with PTO if it's not already written down. That's really going to look like retaliation. So make sure that you have those policies kind of all intertwined with one another and that they're all coordinated properly. Another huge pinch point, especially for manufacturers, is the intermittent leave. My goodness. I don't know if anybody here has experienced intermittent bonding leave yet, but it's really challenging to work through with an employee. I get a lot of questions, and the best advice that I can give employers is to work with the employee to understand what their foreseeable leave needs are as much in advance as you can. Under the law, there is a requirement that employees coordinate that with the employees, not to unduly disrupt business operations. However, there is no teeth to that provision. Well, it says that you still can't make them change their leave schedule to fit your business's needs. So it really does need to be sort of like an interactive process with the employee to figure out how you guys can compromise in figuring out what that leave schedule looks like. Expansive non-retaliation provisions. Holy smokes. So there are a million tripwires with this law in ways that employers can inadvertently interfere, retaliate with an employee's Minnesota paid leave. And now more than ever, employees understand what their rights are in regards to these laws. I have dealt with state investigators that are very green, that were hired by deed to enforce this law, and the penalties stack so insanely fast. It is a 10,000 up to, so the statutory maximum for penalties for interference or retaliation with the law, it is up to $10,000 per occurrence. So you really want to be sure you are clear in your administration of this leave in terms of when you can ask for certifications, when you can ask for doctor's notes, when you can push back on scheduling if it's intermittent, when you can even reach out to them with work questions while they're on leave. I mean, just everything you really, you want to go into this with eyes wide open in looking at it through the worst case scenario lens, because before you know it, those penalties can really get into 100,000 plus territory. FMLA compliance. This is another frequent question that I get. You still want to go through the FMLA paperwork and certify and designate the leave as FMLA during the time that they are on Minnesota paid leave. Not only so that it runs concurrently, but also so that you are not tripping over the obligations that the U.S. Department of Labor on the federal side has been very clear on, that it is an employer's obligation to provide those notices. And when you have enough information to know that it would qualify under FMLA, to designate it as such. Some employers are getting a lot of pushback from employees because of paperwork overload, and they're like, seriously, I had to do all this paperwork for the state, and now you're making me do the paperwork. And the answer is yes, I am. And under the law, I have to. But if they just absolutely refuse to get that FMLA paperwork figured out, you can request from them that they provide you with the physician certification that they provided to the state or your third-party insurer for Minnesota paid leave, and you can designate it as FMLA without making them fill out the FMLA paperwork. Okay. Any questions about Minnesota paid leave? Or any hypotheticals anyone has that they want to run through? Okay. Okay. Switching gears to performance management through the lens of a manufacturer. So when it comes to performance management in Minnesota, generally the laws really that you want to be mindful of, the big ones, Americans with Disabilities Act, ADA, Title VII, or other state equivalent. So here in Minnesota, it would be the Minnesota Human Rights Department. Or if you want to get more granular, it can also be enforced under Minneapolis ordinance or St. Paul ordinance. Earned Sick and Safe Time Act or other state or local equivalent, as well as a number of different whistleblower protections if the employee has reported any type of illegal conduct. Okay, so the slides I'm going to be going through here are really laying the foundation for performance management and really giving ideas on how you can provide coaching and training to your supervisors. Again, supervisors are the ones that are on the floor enforcing these policies, working through performance management, working through coaching. And if they don't have any visibility into how these laws affect their decisions as a supervisor, really puts the company in a scary place. So coaching, the foundation, supervisors really need to be aware that coaching needs to be consistent, sometimes scheduled, distraction-free, encouraging, challenging, providing a plan to follow up on, and documenting the conversation. Based on that documentation from those one-on-one meetings, if it's at a point where there needs to be one-on-one check-ins, even if it's just a few minutes in an office once every 2 weeks, there should be some form of documentation that the conversation was had. Nothing should be a surprise, but it should be challenging. Documenting, did the employee agree with the goal, that the goals were reasonable? Did the employee concede to shortcomings that were identified? These are great things to jot down. When I get documentation from one of my clients that includes these pointers, I am so pleased because it just paves such an easy way to defend an employer's conduct when we have something scribbled down on a piece of paper even, or an email they sent to themselves saying, I told them that they needed to do X, Y, and Z, and they agreed with me that they weren't doing that. And if that is sent contemporaneously or written down contemporaneously, like following the date that the conversation or the coaching occurred, chef's kiss. It's wonderful. It really provides a fantastic foundation to defend. Okay, so once further action is needed, so the employee has failed to take actions agreed upon, work and projects are falling through the cracks, repetitive mistakes are being made, constant supervisor reminders are needed, policies are not being followed. This is all like classic. This is when you guys probably generally start to get the phone calls being like, I'm ready to terminate. But think again, supervisors, because it really is important if any of those laws that I identified on the front end, that the documentation is really solid. So elements included in supervisor documentation, the best practices that really need to be trained on with supervisors, really name and date of the author. If you are writing these things down, supervisor, you need to put your name on it and the date. Otherwise, it's not super helpful. The name of the employee underperforming. You in your head know who you are writing the note about, but if it's not on the piece of paper or in the email you sent to yourself, it's not super helpful. And a summary. So description of the performance issue or conduct that warranted the feedback with examples. Summary can even be super, just one sentence that this is the second time we've talked about it or third time, whatever. Explanation of why the issue is important, how it falls into the review structure, goals, values, whatever. Explanation of how the employee has been instructed to correct the problem and how you're going to monitor it. Review, revise, finalize. No just like stream of conscience, because that's hard to track, hard to figure out the significance, and usually there's not great information in those. So again, the documentation pitfalls that your supervisors want to be, I know this is like all such common sense to this group here, but the pitfalls to be aware of to train your supervisors on really are failing to document contemporaneously. So when the conduct is occurring, when I do trainings for supervisors, a lot of them are surprised, or maybe they just hadn't ever thought of it, that they make a document in Word. There is metadata behind that document that shows when it was created or shows when it was typed in. And if you're being sued and you get to the discovery phase and you send it off, it's a bad look to have your documentation all drafted up and typed up into a Word document or emailed to yourself after they have already initiated legal action. Failing to be honest, failing to review, and failing to retain. Those are the other pitfalls that I see a lot. Okay, involving HR. So for HR-related complaints, documentation, best practices, discuss over a call. And when I talk about HR-related complaints, I'm talking about complaints about violations of the anti-harassment or anti-discrimination, any of those HR policies where legal is implicated. It really is better to discuss over a call versus email, because all of those conversations and emails exchanged, they're discoverable if a lawsuit is initiated. When taking notes, discussing personnel issues with the supervisor, I always advise HR professionals not to directly transcribe what the employee is saying. Obviously, review and correct before finalizing. I know it's hard, but try to avoid comments and your own assessments about exposure and liability. The last thing that you want to have to produce to the other side is, this feels like a lawsuit, or I think the law was broken, or I think that they harassed so-and-so and nobody did anything about it. Definitely want to address is helpful from a litigation perspective. Notes of conversations with legal. Try to avoid that. Try to avoid sending your attorney the email that your employment attorney sent you. Don't send that to somebody else, because that can sometimes inadvertently break the chain of privilege and make it discoverable. Label, date, and sign, and follow up with the supervisor. A lot of my clients, they want to be able to rely on supervisors to come to them if issues persist, but it's just doesn't happen. So you want to obviously follow up with supervisors to make sure these issues just aren't going by the wayside. And I'm sure everyone can relate to receiving the phone call like, okay, I'm ready to terminate. It's like, haven't heard from you in a year about this. Why now? So following up really kind of helps proactively keeping them on task as well. Okay, in terms of disciplinary considerations, this is just kind of a checklist of like what I go through in my mind. Obviously, was there a protected action that the employee took that we need to be mindful of before moving towards disciplinary action? Was there a request for an accommodation, disclosure of a disability, request for leave? Did they just get back from protected sick time use? Did they report harassment or even just cooperate in an investigation? Are they under workers' comp, or did they recently file a workers' comp claim? What's the temporal proximity? That's really huge in cases too. So how much time has passed since the protected action was taken? Were there warnings or discussions of performance shortcomings prior to any protected action? If not, why isn't it an issue now? Are similarly situated employees held to the same standards? It's kind of just like the laundry list of items that I generally walk through when having these conversations with HR leaders or supervisors. Has the employee complained about illegal or unfair treatment or even safety concerns? Does the employee have a contract for employment or other agreement that would somehow limit their at-will status? Has the employee signed the handbook acknowledgement or affirmed in writing that they understand the position and conduct standards at the organization? And then these are just like some kind of extras. Consider the supervisor always. Have there been past issues with the decision maker or the employee? Are there reasons for discipline or discharge that would be subjective or objective? Has the discipline and messaging been consistent with the employee? Like, is it kind of a flip-flop situation depending on the supervisor's mood? Is there exaggeration or embellishment? Sometimes you'll have a supervisor that just does not like the employee, and you can see it from a mile away that they are treating them differently. And you know it's not based on a protected class. But at the end of the day, that's what's claimed. And that's usually a pretty good argument if there is considerable evidence that they are even just being treated different than other employees. After reviewing the record, does the company appear to have treated the employee in a fair manner? This goes such a long ways, especially when talking about settlement value. If there is a high reputational risk based on the facts that are going to be disputed in a trial, that drives up settlement value. Plaintiffs' attorneys can spot that a mile away, and they know that there is a price on that. Okay. Disciplinary options. I'm going to kind of breeze through these because you guys know all of this and we're running low on time. These are just basics on performance management, best practices, most important, consistent follow-up and follow through. From an HR perspective, when you're involved, it's so good to just know, even though it's kind of daunting, that if the issue does end up in litigation, even if you were just the HR employee or leader that had firsthand insight into what was occurring, you're going to be deposed. You're going to be asked detailed questions about what information did you collect? What formed the basis for your decision? Give us information on other similar decisions made. Discovery unearths emails and text messages related to individuals. For whatever reason, a lot of supervisors don't think that text messages are discoverable. So that's a key point in training your supervisors, is that if you're not comfortable putting in an email, don't be comfortable putting it in a text message, because that can just as easily be discoverable. Testimony might be taken years down the road, which really highlights the importance of having that solid documentation, having dates, having names, having everything kind of in a nice, tidy package. So some of the challenges when defending employment claims: lack of corroborating information, the data is bad, inaccurate documentation, demonstrating performance shortcomings or feedback. It always turns into a he said, she said. Communications with the employee, setting reasonable expectations, perfect performance reviews, and then all of a sudden a termination. That's a tricky one. Delayed discipline always risks events happening in the interim that make discipline look retaliatory. So if the discipline was so important or the policy violation was so serious, why did you delay it until they took a leave? All of that stuff, it's just, you got to stay on them. Actions based on assumptions, undocumented client or coworker complaints. Having a complaint from a customer, vendor, colleague, having those documented complaints really adds it paints a better picture that it is not just a supervisor singling out this employee. It is actually a comprehensive issue that multiple people are grappling with. So keeping that type of documentation is also really helpful. The hard facts to fight in a claim come down to things like this that I hear on a regular basis. The internal deadlines were not in writing. I gave plenty of warnings, but none of them were in writing. I never wrote down summaries of the meetings we had, but I can write it down now. Yes, I gave a different employee a written warning for similar infractions in the past, but that was an entirely different situation. Consistency, documentation, follow through, involve legal when necessary. I don't think we have time for the example, but it's pretty good. So for those of you who want the slides, you can kind of go through this hypothetical that I had here about supervisor calling HR and wanting to terminate someone, and kind of how you respond. I have everything bulleted out and like kind of my fact finding route that I take. The legal landscape associated with the example. Sorry, I have like 2 minutes. Termination considerations. These are kind of like some of the softer considerations, but still super important. The supervisor allowed the employee to maintain their dignity throughout the process. Juries are comprised primarily of employees, not employers. So if the facts all show that this employee was treated like complete crap by the employer, that's going to matter. Even though it's not illegal to be rude or illegal to be mean, it will affect their decision making. Has the company adhered to principles of fairness and with consistency, and is that reflected in the record? If legal risks are present, have you sought a second opinion or had the documentation reviewed by someone else, such as an employment attorney? Can make a world of difference. A lot of my practice is built upon HR leaders calling me just to get a gut check. And I cannot tell you how much money I have saved employers just with a 6-minute phone call, just a quick gut check, to make sure nothing's being overlooked in terms of risk mitigation. So closing words, if you follow a consistent and fair process, the employee is less likely to take legal action. Let me see if, sorry, I thought I saw a message. That is largely my experience. If someone feels slighted, they're typically going to be more empowered to find an attorney to fight it out. So I wanted to save the last minute or two for questions. I know I went through just a ton of material, but it was hard to pare it down. Okay, question, great. We always had 2 15-minute breaks and a 30-minute unpaid lunch break before the state policy was in place. We have morning break, 9:35 to 9:50, lunch, 12 to 12:30. All employees know the times, etc. We have one employee, hypothetically, one employee who voluntarily decides to work through breaks and lunch. I must have him sign a sheet 3 times a day for voluntarily not taking the breaks. If it is that consistent that it is like clockwork every single day that he is going to not take the breaks, I think having him sign something for every single occurrence is just not sustainable. But I also wouldn't just lean on one single signature. Maybe at the end of each week or the end of each month, you have a special certification. This is just me thinking out loud. For this hypothetical question, you have a certification at the end of each month that this employee signs, that has maybe it's like a printout out of your HRIS system or payroll system, and he signs attesting that he voluntarily skipped all of those breaks and that he had the opportunity to take them, but didn't want to. So maybe you handle that particular employee on a monthly basis. That probably feels a little bit more possible and practical. Any other questions? Don't think I see any typing. Thank you so much for attending. Oh, you're welcome, Michelle. My email address, phone number there. If you have any follow-up questions, give me a call, shoot me an email. Happy to talk. If you have any more hypothetical questions, I'm happy to go through those as well with you over email or a call.
All right, Bethany. Well, thank you so much for your expertise and your time. That was wonderful. So also, if any of you need to get a hold of Bethany and you misplace her email address, please reach out to us at Midwest Manufacturers and we'll definitely put you in touch. All right.
Guys. Nice to meet everyone. Have a great day.
Thanks.
Bye.
Bye.